and welcome to the next lecture in the series of Struggle to Success Journeys in Law. We started this lecture series with an idea that our young members who have just come into practice should know that the success achieved by stalwarts in the legal profession, the successful people in the legal profession, is not something which has come to them suddenly, but they too have gone through a great deal of struggle, a great deal of hardship before they have achieved the status and the stature which they have achieved. And that is a result of a lot of struggle, a lot of hard work, a lot of toil over the years. And as in any other aspect of society in India, the struggle of a lady in the legal profession are particularly unique. And that would be evident from the fact that with the history of our court dating to almost more than a century, Justice Dalvi was only, I think, the sixth lady judge of this court. So over 100 years, more than 100 years, Justice Dalvi, I think, was effectively the sixth lady judge of this court. And today also, if you leave aside the judges who are still sitting, and if you count the former judges, lady judges, they are not more than 8 to 10. So that shows how the ladies have struggled over the years to make a mark in the legal profession. And Justice Dalvi is one such person who came up from being a lawyer to the level of the City Civil Court judge and thereafter a judge of this court for several years. And she would be an inspiration to lady lawyers who dream to achieve great heights in the profession. So we thank Justice Dalvi for being in our midst today and to speak to our members. May I request our President, Dr. Sathe, to please make the opening remarks.
Justice Roshan Dalvi, who is also the part of the Bombay Bar Association, and my friends. When we conceived this idea, as Biren mentioned, to have a series titled Struggle to Success in Legal Profession, I had in mind the literature form called biographies and autobiographies. And I have been from childhood a great reader of biographies and autobiographies, and they have always fascinated me. While you read the biographies and autobiographies of a person whom obviously like to know about, you always compare that he became at age of 21 so and so, or he did something at age of 21 something, or he became judge at age of 45, 40 or 38. Justice Verma became judge at age of 38. So all lawyers look at that and they think about their course of life. In that manner, the course or the journey of a person, particularly who is a struggler, who has not come with a silver spoon in his mouth, is very fascinating and interesting, and that makes this lecture series interesting. This evening's guest, who is not a guest, Justice Roshan Dalvi, is an ideal candidate, as Biren mentioned, from variety of points. I have known Justice Dalvi when she, with her senior, had a conference with my senior, Justice Senior Dhanuka, her senior, Mr. Bomiz Haiwala, and they were all together doing a company law matter under section 397, which is the operation and mismanagement. And I was so impressed with Roshan Dalvi, who was ready with everything, including the judgments, the Junjunwala and that Ibrahimi judgments, etc., which I had never heard before when she mentioned about those. That's the one. Then, of course, I have seen her as alumni of Government Law College. Then she became the judge of the City Civil Court and, of course, judge of the Bombay High Court. And one thing everybody would agree about Justice Roshan Dalvi, with her variety of ways and the innovative ways of doing justice, you can love her, you can hate her, but you cannot ignore Justice Dalvi. And that speaks about her unique persona. And that's what we are going to hear about from her, about her unique journey into the success which she has achieved, and that's what we are anxiously waiting. I once again thank Justice Dalvi for being with us this evening. Thank you.
Thank you, Dr. Sathe. Since Dr. Sathe has spoken about autobiographies, I must mention that today's talk by Justice Dalvi will in fact serve like a curtain raiser to her memoirs, which she is releasing in January which we are all looking forward to, which is proposed to be released here itself. So we are all looking forward to hearing Justice Dalvi. May I request, Madam, please address our members.
Good evening, Mr. President, Mr. Secretary, and friends. Our President Abdul Kalam told the youngsters of our country, dream, dream, dream. What they say is that you must build castles in the air and then build a firm foundation below them. And that's what starts a life. You will be wanting to have some breaks. And it's nice to have young people listen to you because it's like a battery. It charges us. That there are some youngsters who might follow some of us. Now, as you go into the world, you will find you'll have to have interviews, you'll have to give interviews and take interviews later in your lives, and you have to find out talent from the people. There was once an attorney's firm, extremely radical and very progressive. This attorney wanted to hire a lawyer. Knowing what lawyers really do, he devised a new model for his interview. He called in all the applicants together and he told them that I'm going to tell you a story and I want questions. I do not want answers because I will not ask you questions. He said that there was a farmer. He had a field. He harvested his crop. He put all his crop in a barn. In the night, he wanted to see his crop one day. So he goes in with a lamp. A rat comes out and goes out from the barn. The farmer topples over the rat. The light in his hand falls down on the barn. The crop catch fire. The barn burns out. And he says the farmer is left bereft. But he does not ask any questions. So he says, yes, what are your questions? Lawyers that these people were thought of many, many things, like they think of many, many arguments. Somebody said, why did the farmer go in? Somebody said, how much was the crop? Somebody said, what is the value of that crop? One wise man said, was he insured? And the man went on listening until one little boy, who wasn't much of a lawyer but had brute common sense, asked a little question. But sir, what happened to the rat? He got the job. Not the rat, the boy. That is the real intrinsic value of a lawyer. When any client comes to you, to get to the point, to grasp what is his real needs and desires, is when you do service. When I was a little girl in the law college, and before that in the commerce college, my first love was business management. I wanted to be an executive of a company. But then law took over, and as law grows on you, I decided, no, I'm going to do law also. So after specializing in business management, I didn't go into any law business school. I went into government law college. And as we were learning law, and I liked it more and more, I thought this is the time to study, then is the time to practice. And I wanted to practice. Little did I know how long I would have had to wait to get what were my dreams and desires. I had also built castles in the air. I was trying to build a foundation under them. It was not complete. We finished our graduation. I went to work in my father's office. Then I went on the first day to court. And I never understood what I've still today not understood after 43 years. Why people only come to take adjournment. I feel the substratum of the lawyer goes. Because he wants to argue, he wants to be a litigator, and he doesn't do a litigator's job. So I spent a whole day in various courts, and I was bored to death. Nobody was going on, I thought. I didn't hear something, really fiery, or any judge being fiery. In the evening, I told my father and his partner that my whole day is wasted. I thought my career will come to an end. And I said, please give me something to do. So they gave me a small matter of a pauper. It was a pauper petition. And there used to be a kind of a practice that you tell the prothonotary that you are prepared to work pro bono for somebody. So he gives you a pauper petition and it's converted into a suit. This was a man, my first client, who was a lone man, very simple, very poor. He said that he had designed that blue logo of Tata's. The T that you see in very many places. That he said he had designed. And he said the Tata companies, 10 of which were defendants, huge Tata companies, agreed to pay him 500 rupees per month for the rest of his life, or 5 lakhs of rupees at one time. Now I thought, this poor man, and this 10 Tata companies not giving anything. I was his man Friday. And I said, I'm going to get it for him. The stage of the suit was that the petition was just filed. It was so hopelessly drafted that we had to make an amendment of the plaint. And the amendment of the plaint was such that we might as well tell the court that please give me back this plaint and you take this plaint. Every single thing had to be amended. So I sat down with the amendments. It was drafted and I had to work on those amendments, fill up the blanks, etc. with him. We did the amendments. I showed it to my seniors. It was filed in court. There was a chamber summons. I started looking up the law. Order 6, Rule 17. I thought it was something really great. And I spent hours and days and weeks over that one matter. It came up before a judge who removed it from his board because he was a shareholder in one of the 10 companies. Went to another judge similarly, until the associate said that now I'll find out which judge can take it up, so that then we'll put it before that judge. And that judge was Justice Gandhi. You may not know him. He died in harness, God bless him. A very fine judge. So it came up before him and I was so eager to argue. I didn't want any adjournment, of course. And that time we used to have what were called attorneys' baskets. So we never had anything on computers, nothing on the internet, no Xerox copies also. It was 1976. And the attorneys' baskets with all the law journals would go to court. So I had 2 baskets on that day of 2 of my seniors. And I kept them all on the table and I was just ready to argue. Matter reached and I said, this is an application for amendment and order 6, rule 17, etc., etc. And I said, there are so many judgments, etc. This is my client. The judge bellowed, wait, why don't you settle? These are some reasonable parties. If you say something reasonable, we can work out. So I said, no, my lord, I don't want to settle. I want to argue. And then somebody pulled my gown and somebody pushed me at the back. And they said, no, you can't talk like that to the judge. But I said, no, I want to argue, so I'm just telling him. It was the truth. Then he said, no, tell the judge that yes. So I said, okay, yes, hoping that it is not settled, but I can argue and then he may settle. And the judge gave me a piece of paper and said, tell your client to write down the figure. So my attorney, we told him, write down a figure. He started writing down. And as I was always taught when I was a little girl, not to look into somebody's letters, not to open anybody's letters, I thought this is between him and the court. So I didn't look into it. He wrote and he put it together, a small little chit, and I passed it on without seeing. So again somebody is pulling my gown. And I look at it first, what has he written? And I said, why should I look at what he has written? The judge will see. We saw. Anyway, he had written 2000. He was so nervous. He wrote 2000. So then they started asking him, Mr. Mani, you want 2000 rupees? He's saying, no sir, 2 lakhs at least. He's saying, what have you written? You've written 2000. Put a zero. Put zero. He said. So he put 1 0. It became 20,000. Then again we had to tell him, put a zero if you want 2 lakhs. Is it that you want 2 lakhs? Whatever he wants. And it went up to the judge. Judge saw and felt it was very exorbitant to ask 10 Tata companies to pay 1/10 each. So he said, forget this. Argue. And I was as happy as a lark. I argued. At that time I thought I should get a doctorate in Order 6 Rule 17 because that was all I had done. After I finished, some of the people started saying that, you must go to the judge in the chamber and say sorry. And I was just wondering, for what will I say sorry? For speaking the truth, for telling him that I want to argue when I am here in my career to argue. That's all I wanted to do. Anyway, I went. And the judge called me in with my seniors. And I didn't know what to say, why I am sorry, but I said I was sorry. Don't worry. We shout sometimes. You've done your job very well. You'll go far. Okay, he said. So we came out. And I was very happy. But I was thinking, what a stupid fellow, he's laughing. He's shouting at me and then he's saying, you'll go far. But anyway, then I started appearing in his court. There was a second matter which I did in his court, which was a direction matter, a direction petition under 302 of the Indian Succession Act. We had to take in an estate of a deceased various directions which attorneys take. So I went and he gave us a lot of directions, various things had to be done, the estate had to be administered. And he said, okay, and he threw the papers. I said, no my lord, one more thing. What? I said, my lord, prayer M. Now these were prayers A to N. And I was asking for prayer M. I didn't say anything else. So he opened again the notice of motion which was there. And prayer M was for costs. Pada! He threw the papers. That's enough, he said. And then I was told that, well, you've done very well and that's okay, forget about the costs. And I thought, well, what did I learn in LLB? I learned that costs follow the event. Therefore, in every single matter, costs must follow the event. He gave us so many directions and he never gave us the costs. So it wasn't as per my theory of law. Things went on and we make mistakes. We earn little, we do more and we make more mistakes. And as they say, if you don't make mistakes, you don't do anything. So it's not the mistakes that count. It is not that you are failed, but that you have not risen up. So you have to go on. But I had that kick in my head always that I don't like adjournments. And if I were to apply for an adjournment, I would feel so bad that I would wonder who is looking at me. Because they will feel that I'm such an important lawyer, who's asking for an adjournment. So once there was a summons for judgment. We had filed a summary suit. We got the affidavit in reply on the last day. So when my father saw it, he said, okay, oh yeah, there are all these things written, we will have to file a rejoinder. You take 2 weeks. So I told him, I said, if you have to take 2 weeks, then you go and take 2 weeks, no? Next time I'll go and argue. And he got so wild, what do you mean? You can't take adjournments anytime? So I went to take adjournments, died 100 deaths, thought, I hope nobody has seen me do such a stupid thing. Then of course, I argued at other matters. Then at that time, it was 1976 and the dual system was on. So, and this was in 1977 that I told you, right? But in 1976, the dual system when it was on, we could not appear in the High Court. So I had to work with the counsels whom my firm had briefed. And I had to go behind them, do nothing really, but except in conferences when I could do something. So I decided it's much better to appear and argue in the city civil court where I can, rather than just tail behind the seniors in the high court when I can't do anything. So I started doing that. And I went once for a suit, it was before Justice Rayleigh, and the defendant applied for an adjournment on the ground that is moving an amendment, took out a chamber summons for amendment. So my managing clerk tells me from the back, "Lai, tu pan kahi de ki humne pan amendment karvi us plaint ne." Without thinking, I told the judge, "I also want to amend my plaint." And the judge almost balked. He wants to amend his defense, therefore you want to amend your cause of action. And I was so stunned and I thought, oh my God, I've made some great error. And I said, like, I'll never forgive you. Why did you tell me this? You must not prompt like that, etc., etc. Little did I realize that nobody thinks much of it. We all make mistakes. I thought my career was ruined if I ever made a mistake. And it went on like this. Then I was told that if you want to really learn the law, you should give tutorials in government law college. We used to have tutorials, now they don't have. We had to go 45 minutes 3 times a week in the evenings. So I said I'll be a tutor. I applied and I got that. And I had to tutor some of the students who come behind us, a couple of years ago. I used to earn 60 rupees per month for going 3 times a week for 45 minutes. So I thought it added to my income. Then somebody told me, you are in an attorney's office and all, and you must learn to go to all sorts of officers. No point only going to court because you will never understand everything. So I started going to the court receiver, the official assignee, the official receiver, the company registrar, and all of those, because there I could appear. Then somebody told me that this is not enough, if you really want to be a good counsel, you must lecture. And after 3 years of practice, we become eligible to lecture. So immediately after 3 years of practice, I applied. So that I can read up the law, I can talk to the students, so I'll be able to speak in the court. I couldn't click in the government law college, and I got an opportunity in Bajaj Institute of Management, which I liked very much. So I was teaching them company law, secretarial practice, and in a couple of years commercial laws. This I did for 10 years. I remember when I went for my interview, the president of Nirlon, because this is a management institute, so it's manned by all of those management people, he told me, yes, I am appointing you. You have to do company law in 15 days, that is 15 weekends, Saturday and Sunday. And you have to make them managers, not lawyers. So I knew that I didn't have to do the case law. I had to do only the bare text and tell them how companies work. I did that until I became the judge. I could not do that thereafter. One very important thing, we cannot do any work when we become a judge because we cannot have 2 incomes. This is the only income we have. One of the things that we were always required to do was to correct the papers of our own group in each management college. So I had a group of 20 students doing this management course, and I had to set the paper and correct the paper for this marks. Now in the meantime, before the papers could come to me from the university, I was appointed judge. Now my first quandary was, can I or can I not do that? Because I'm going to earn. And somebody said, you ask the Chief Justice, somebody said, you ask the registrar. And I said, I have to decide. So I decided and I said, if I don't do, my students are going to suffer. Because other colleges will have their own lecturers give these marks and I don't give my marks. It's not proper. So I corrected the papers without asking anyone. I earned 200 rupees check for 20 papers at the rate of 10 rupees per paper at that time. It was in 1989. And I still have that check. I did not encash it. And I thought that was sufficient compliance. But I didn't want to take anybody else's advice. I advised myself. I was a bloody judge. So I judged that. This is the way things go on in our lives. And we kind of earn and make our supplementary earnings until we find that now we've got enough and we shouldn't take more or anything like that. Some of these stories leave me with certain things to tell you before I forget and before I go out, because it's my duty to talk today. And I would say that whatever opportunities that we had had at that time, 43 years ago when we became lawyers, were so different from what is today. Today these youngsters, you have got so many avenues open. Even as a litigator, two important things which are open and which I saw in my court for real youngsters to come up with a real good training are: one, client counseling for mediation. You can be your own master. You will be a kind of a semi-judge. There are lawyers who are trained in that in Canada whom I have seen, and they start their practice and they come together to make firms, to have negotiation skills and deals with other parties. So they have a kind of a table practice, but they are practicing mediators, practicing lawyers. They know the law and they do it. I don't really know why that cannot take over. The second thing is what I did in my little way, in my court, is the court commissioners that all youngsters can do. Instead of going with your senior and doing nothing and sitting, it's much better to record the evidence that two seniors who are cross-examining are recording, because at each sentence that is taken down, you are learning something and your mind is occupied. And I think it's a very good exercise. Even if some people say that this kind of evidence is no good, it's very verbose, etc., etc., it is for the judge to read it up at home, and once that is done, it becomes fine, because then the judge knows what to eliminate and what to take. But that is a good field that is opening up for you all. In our days, we used to do this tutorials, etc., as you said, and I, being a lady at that time, and again, now we have come of age in gender, but at that time we were not. I used to fight for equal rights and equal opportunities. I used to give paralegal trainings to those young, you see, cooperative societies and labor people, etc., somewhere in companies, to say that these are the women's rights and these are the women's laws. Now we don't have to do that. We know that we are equals, we are treated as equals. At least on that ground, I don't find much bias. As we go along, I find that there are so many professions that go with law. For example, economics goes with law, finance goes with law, accounting goes with law, sociology goes, political science goes, even some of the science subjects go for patent, etc., all those laws. And I have not understood why management cannot go with law. I had done management in my undergraduation, and of course, as I told you, I didn't go into management school. But I find that though we are on par with any in the world on our substantive lawyers as well as judges, the law itself and our courts and judgments, we fall so short in our procedural laws, in our access to justice and the delays and arrears. And good management experts can make fine lawyers, and fine lawyers make fine judges. And I think that this is one sector which is missed. And if any one of you all, young as you all are, if you can take it up, it's an ideal thing where you will be able to put business management principles into the profession of law. I have done that in my individual way in my court, and I have found that it has worked. Up to a point, because I am the only one who has done it. And when I tell others, it appears that people are receptive to it. It is that you must be professionals in it. When we talk about how to work and how to manage, I would really like to tell you one story which is really of management and which applies to lawyers and judges. In a business school, a professor goes with big rocks, small stones, some gravel, some sand, a pitcher of water and a tumbler. As soon as he goes to class, he starts putting in the big rocks into the tumbler. He asks his students, is the tumbler full? Students look and say, yes sir, it's full. Then he puts the smaller stones in between those other stones. Again he asks them, is the tumbler full? They say, yes, now it's full. Then he puts gravel and sprinkles sand. Everything goes in. He just shakes the tumbler a little bit. And then they feel, oh, now it is really full. And then he picks up the pitcher of water and he pours the water until it comes to the brim. And then he asks his students, what is the moral of this story? So since they were business students, they say, whenever there is time and space to do still more, which is what we always say in law, there is time and space to do still more. The professor says, well, that is a very good quote, but that is not the moral of this story. The moral of this story, he said, is, if you don't put in the big rocks first, you will never be able to put them in your pitcher afterwards. Now please consider this story for our areas, our lawyers and judges. We do all sorts of small things first. Your seniors may have even taught you how to do that very well first. But we don't do the big things so often. We have ad interim reliefs, but we don't come to final stages. We have bail matters, but the accused go on waiting in the courts. This is what happens. And if you have to make a difference, and if you have to earn by doing something good, remember to put in your big rocks first in the day. I used to think of my big rocks, and I used to call it FOB and HOB, if any one of you remember. I had those first on board matters which I will never, never, ever adjourn, because they are part heard and have to go on, and I have read them and they have to come to a completion. Then there were those HOB, which is high on board, which was just next, which have become ready and then also I won't. Those were my hard, big rocks. When I finished that, when I finished my entire judicial career, and on the last day, when I was given the farewell dinner by my acting Chief Justice, Justice Tahir Ramani at that time, I didn't even know that this was going on in the court. But I was told that you have disposed of 21,283 matters, 520 reported judgments, and some 287 unreported judgments or something like that. And I had not heard of this before for other judges. I was just wondering why. But I may tell you that most of those were matters which were finished. Now out of those 21,000, I've worked for 10 years, 4 months. It would be about, on an average, 2,100 per year. We work for 210 days. So on an average, about 10 per day. And I don't know whether it includes those judgments and orders and contested, uncontested, I'm not sure. Assuming it includes, it's only 10, if not a couple of more other judgments. And I think if everyone can do this, and if it can finish, we'll finish off our arrears of some 3.7 crores which are there, about 10 years time, at least. So, who can do it? It is the lawyers who are the catalysts. And who can achieve it? It is the judges who are the cooks. And I hope that dish is well served. So I would say, good luck to you. God bless. Godspeed. There are many parking spaces in the road to success. Enjoy the journey. and you will definitely come to your destination. All the best.
Thank you, madam. It's indeed inspiring to know that every person who's there at the top of the profession has also started with an Order 6 Rule 17 application, and whenever they lost a case, they thought it was the end of the career. I remember once I tried making a submission in Justice Dalvi's court, where I said the plaintiff says defendant number 2 is the karta of an HUF, and defendant number 2 is a lady, how can she be a karta? So she looked at me and said, anything that the man can do, the woman can do equally well, if not better. And being the lawyer, I immediately said, yes, my lady, I'm here only because of the support of my mother. She said, that's better, go on. And she's a living example of that anything that a man can do, a woman can do equally well and even better. On behalf of the Bar Association, I thank Justice Dalvi for spending time to be with us this evening and to speak to our members. I'm sure the members will be enriched by hearing her experience and will look forward to your memoirs. And on behalf of the association, may I request Ms. Apurva Thipse to please present a small memento to Justice Dalvi. Thank you, ma'am. Thank you all very much for remaining present today, and have a good evening, and please have some tea and biscuits before you all leave. Thank you.